everyone, and welcome to another exciting edition of the ESQ Practical Lawyers Academy free webinar series. We are glad you could join us today. My name is Chidima Agu, and I am a Research and Development Associate at ESQ Trainings Limited, and I will also be the moderator for today's webinar. At ESQ Trainings Limited, our mission is to expand the frontiers of continuous professional learning with courses and trainings across various areas of practice. We have tagged this webinar series the Launch Hour webinar series, as they are slated to hold at 1 p.m. during lunch break. They will hold 3 times every week, Mondays, Wednesdays, and Fridays. However, in order to accommodate our Muslim participants, the Friday webinars will hold at 11 a.m. And after every session, we'll provide the resources in easily accessible format for everyone who's interested. So our training on mining agreement, contract, and transaction issues starts on the 19th of April to 23rd of April, and it goes for just 100,000 naira. We also have another training for 5 weeks on the mechanics of oil and gas contracts, and it runs through 22nd of April to 20th of May, and it goes for 200,000 naira. So if you're interested, just send me a mail on the email address I'm going to put, and or you can comment in the chat session. So you can now watch our webinars on YouTube and at my ESQ Legal. And after watching it, please subscribe to our YouTube channel. So on today's topic, we are going to be discussing conflict and confidentiality. And some of the things that will be discussed today: scenarios of conflicts in a work environment, exceptions to duty of confidentiality, cases and precedents of conflict and confidentiality, and many more topics our speakers will be buttressing on. So if you have any questions while the webinar is going on, please type in the Q&A or raise your hand, and in due time it will be answered. So with this, I'll introduce our speakers for today. Mrs. Adiola Olumeyo, she's not here yet, but she's the Assistant General Counsel and Company Secretary at Channels Television. So she'll be joining us shortly. We also have Mr. Leo Kafo. He's the General Counsel and the Group Company Secretary at the United Capital PLC. Welcome, sir. Thank you for joining us
Thank
today.
you.
Yes, we have Mr. Augustine Ungu. He's going to join us shortly. He's the lead at Amalgam Legal. And we have Dolapo Moniola Olunloyo. She's the head legal at Bell's Law Consult. Thank you, Dolapo, for joining us here today. We also have Aramide Wokeduko. Yes, thank you for joining us here today. She's the Group Company Secretary / Head of Legal at CFAO. We also have Ugona Ogwagu. He's the Senior Associate at ALEX. Thank you for joining us today. So we are honored to have you all as our panelists on this session. So yes, we'll start the conversation now. So basically there are conflicts. Conflict is a normal and natural part of any workplace and any relationship entirely. And conflict in a workplace is basically inevitable, especially when there are employees from various spheres of life, various backgrounds, and different work styles are brought together for a shared business purpose. So conflict can be personal, conflict can be financial, conflict can be professional, and many more. So there is also, aside from conflict is one of the words we are going to be buttressing on today. There is also the case of confidentiality, which is an ethical and legal principle, and it is important for every professional to hold certain privileged information of their client unless such client authorizes them to disclose that particular information. And it is buttressed more in the legal profession, where lawyers have a professional duty of confidentiality to their clients, to hold certain information. So basically, a lawyer cannot just afford to disclose any kind of information without the consent of the clients. So in this webinar, our panelists would delve and inform us of different ways and of how lawyers and professionals marry these terms of conflict and confidentiality, and how it is being handled in a workplace, the exceptions, and many more. So I would leave it to Mr. Ogona, who opted out to be the first person to speak on today's session. So thank you, Mr. Ogona.
Yeah, thank you, Shudima. Good afternoon, everyone. As earlier introduced, my name is Ubona Obuago. I'm a senior associate with ALEX. I work with the firm's dispute resolution, taxation, and commercial law practice teams. As Shudima alluded to, yes, we have conflicts in the work area. It's something that you cannot run from. But as lawyers, and I mean, of course, that has to be dealt with in accordance with the existing policies within the company. However, as lawyers, when we talk about conflicts, our minds actually run to conflicts of interest if you're looking to marry a term with confidentiality. Conflict of interest is particularly important because it's the touchstone of our legal practice. I mean, we can't, you would have to doubt that a law firm can make money or even do business if the clients who reach out to these lawyers are not confident that the lawyer is completely working for them. Its loyalty to the client cannot be negotiated. It's non-negotiable. The prohibition against conflict of interest actually reflects several competing concerns. The client has to be assured that the lawyer will represent them with undivided loyalty. I remember many years ago years ago, when I was starting out legal practice, I was in Kogi State, then I was serving. And after the court proceedings, the lawyer on the other side was a fellow copper. We stood just outside the court, and we were exchanging pleasantries, just talking and everything. And the client came out, saw me speaking with the lawyer on the opposing side, and almost dragged me away from the place, because as far as he was concerned, we're on opposite sides. You can't have a conversation, you can't have any dealings and things like that. That's how strongly clients feel about showing loyalty to them when you're handling their case. And that then points to the fact that when we are retained as an external counsel, when we are retained by the clients to represent them, we have to instill confidence in them that, oh, we're definitely working for them and we don't have any competing loyalties, which is why in most cases, as the in-house counsel on the webinar will testify, the first thing you would ask an external counsel to do is to conduct a conflict check to make sure that there's absolutely no reason that would, for one to suspect that the lawyer has competing interests. In fact, this issue of conflicts is actually codified in the rules that regulate our conduct or our operations as lawyers. The Rules of Professional Conduct 2007, specifically Rule 17, deals with scenarios that could lead to a charge that a lawyer actually has a conflict of interest in any particular situation. So for instance, if I'm approached to be retained by a client or to do work for someone, and I fail to disclose any relations that I may have with the parties on the other side, or any connection whatsoever with the subject matter of the dispute, then there's a problem. Because Rule 17.1 of the RPC actually says that as a lawyer, you must disclose, you must offer full disclosure to anybody reaching out to you, to be retained for prospective employment in respect of any matter. So if, for instance, the party on the other side, I am a director, married to a director, I've had business dealings with them before, somehow linked to shareholders, to the shareholders of the company on the other side, or somehow related to the individual on the other side, if the opposite party is an individual. By Rule 17.1 of the RPC, I have to disclose that. In fact, in one of the cases where this was an issue, that's the case of Ikeme and Ikwe. In that case, the lawyer had drawn up a partnership agreement between the two parties. When there was no problem, everything was fine. Drew up a partnership agreement, went ahead to execute the agreement. Both parties executed the agreement. But when a dispute arose from that agreement. The lawyer was briefed, one of the parties briefed that same lawyer who prepared the partnership agreement to go and file an action against the other party. And in considering all the facts of the case, one of the points the court made was, come on, you should have disclosed to all the parties involved that you had this interest, you worked on this matter, you prepared the partnership agreement, you had some exposure to the confidential information of the other party, so you should have disclosed that. So that's one duty flowing from the issue of conflict of interest considered on that rule 17. The other point is that financial, business, or personal interest in data, I'm liable to the client, and of course, I'm subject to disciplinary action from the relevant institution. The only exception to this is where I offer full disclosure to the client, and the client then waives that conflict. The other point made under Rule 17 of the RPC is that if after I have accepted a retainer, I've been engaged by a client, I then decide to acquire proprietary interest in respect of that, the subject matter of the dispute, that in itself amounts to a conflict of interest, unless I'm exercising a lien just to make sure that I get paid my fees, or maybe the fee arrangement I have with the client is a contingency arrangement that allows me to get my fees, maybe from the sale of the subject matter of the dispute or from other arrangement between us. That's the only time that I can acquire proprietary interest in the subject matter of the dispute. The other point is that if I accept a retainer or an employment, and I know that based on my circumstances, there's a chance that I may not act fully in the interest of the client, so I have to disclose that. Let's say, for instance, that before I was approached to accept employment, I had actually acted for the opposite party in a different transaction, or have some other existing relationship. It might not be personal this time, it might just be a business relationship. So I've acted for the opposite party in an earlier transaction. It's something that I have to disclose to the client, so the client can decide whether they have to waive conflict. So these things are important points that are made under Rule 17 of the RPC, which deals with conflict of interest. And it's something that we as external counsel pay heed to whenever we're considering whether to accept, an engagement that has been pushed to us. So we won't ordinarily accept briefs which are connected with previous services. We won't accept briefs that we've rendered to a different party. We won't accept briefs where we have some interest in the subject matter of the dispute, unless we've informed the client and the client has decided that, listen, I've heard you, but I still want you. In that case, of course, we'll then choose to go ahead with the retainer. So maybe I'll leave it open for others, especially the in-house counsel. Let's see what their perspective is as it relates to conflict of interest when hiring, in internal operations and when hiring external counsel.
Can I go?
Oh, yes, please.
Okay. Thank you very much, Ogun. I think from the perspective of an in-house counsel, it's two things. One, there's this contention over whether the RPC, whether it also applies to in-house counsel. Some people say that no, it doesn't. It only applies to lawyers acting on behalf of clients, while the general and more common notion is that it also applies to in-house counsel by virtue of the Interpretation Act that defines, or rather the Legal Practitioners Act, that doesn't make a distinction between in-house counsel and external counsel. But by this fact, the common notion really is all the provisions in the RPC as regards conflict of interest, the same way applies to external counsel is the same way applies to in-house counsel as well. And us sitting in-house, we have to assess our actions, particularly as we wear so many hats. We are business advisors, we are employees, we are servants of the board. The way I sit now, and I sit as company secretary, legal advisor. One, I'm a servant of the board. I report to the board. but the board doesn't sit in my office. Yes, I see the members of the board from time to time, but I'm more in touch with my supervisors, which is my MD, my finance director, and these are ultimately my bosses, even though by law they cannot fire me. So how do I marry all those conflicts of interest? My boss calls me that, oh, you need to do XYZ, and it goes against something that the board has instructed me not to do, or it goes against the interest of the company. How do you marry all this given the legal obligations that you have? Those are some of the tricky situations where you need to sort of be careful when you discuss in-house, when you're discussing with your MD. You need to be careful the matters that you need to escalate to the board. So those are some of the considerations that we look out from an in-house perspective when it comes to conflict of interest.
Okay, thank you, Ramide, for the insightful position from your own perspective. I share similar perspective too, but perhaps in a much more deeper way, in the sense that I'm looking more a bit to the Ugona's position and also to yours, and how they have actually interacted with what I do on daily basis, weekly, monthly, and yearly basis. Now, on the issue of conflict, it's, if in my own perspective, it's a very hard conflict, and confidentiality are very hallowed concepts that are grounded with so much etymologies, very much common in institutions and work environments, including law firms as well. I agree with Ugonna when he said, when he has a brief, before they take it on, they run conflict checks. But somehow, sometimes, a few very exceptional firms don't do that. Perhaps maybe guided or influenced by the size of the brief or the benefit they'll get from that brief, sometimes turn a blind eye to those conflict checks. And when I eventually discover, I'm often very disappointed with such persons. In any case, the more question we need to look more now is, are these hallowed concepts observed literally? In other words, are they more observed, are they more popular in breaches than in observance? I would say so. I'm not saying that they're not actually being observed, but sometimes they're observed in breaches than in observance. And because cases don't come up by a regulator or by someone who is pieced by certain actions, people never know that these breaches occur regularly. In organizations such as mine, issues of conflicts and to some extent confidentiality are provided for in policies and manuals that guide everyone, one in their relationship with the organization and with other stakeholders as well. These policies are often seen or regarded as ethical business principles that go to the extent of the reputation of the individual and, above all, that of the organization. Because a breach of conflict of interest can adversely affect and damage that reputation of the organization, even if the individual himself does not care. So what I'll be looking more into in the next couple of minutes is the extent to which these principles or concepts of conflict or confidentiality have actually been addressed or respected by persons. Now, from my experience over 20 years now, there's also I've noticed there's what I call the PP syndrome. That's a private practice syndrome. These are conflicts in the sense that people do the same work for which they were hired. They do it for their personal gains. And I wonder, if you're hired to do a particular job and you take that job as a platform to achieve your own personal gains, there is a conflict. I see it more as, I call it PP syndrome, and that's quite prevalent, whether it's in private practice or in corporate organizations, or even in any other organization. People use the platform of the organization to achieve their own personal gains. This, to me, is not normal. To some people, it's a normal practice, but in reality, it's not normal. It's abnormal because the fact that the issue had not arisen where some level of disciplinary action has been taken, or that they gloss over it, encourage people to do it. And when this is perpetrated over a long period of time, you build a foundation under which they eventually leave the organization and become even sometimes a competitor to that organization. There's nothing wrong in being competing, but where you use the platform of organization to set up yours, now I don't think it's my opinion, it's right to the organization. Now, situations where people poach the clients of the employer for PP purposes or for any other purpose, to me is also a conflict with the letters of their employment or their relationship with their employer. Now, being a supplier to the same organization through third parties or through some vehicles without disclosing this interest, to me, is an issue of conflict. So these are things I've seen not only in my own industry or in other industries, because over a period of 20 years, I've been in different organizations and I've seen all these things play out. And the more damaging one is taking kickbacks. I don't want to use the word egunja, kickbacks or appreciation, if I could use that word. Tokens of appreciation at the detriment of the organization. A lot of organizations have policies that speak to this, but who comply with these policies? Little or no one do comply with these policies. So these things over time eat into the issue of corruption that we even speak about, that people take literally, and then they don't even see what is really the issue in them. So these are on the issue of conflict. These are my thoughts at the moment. And then when we come to confidentiality, I could speak more on that. Thank you.
Thank you. Thank you, Mr. Dolapo, any thoughts?
Sure. Good afternoon, everyone. It's actually nice to be here. It's been educating, and I just want to thank everybody that is here. Actually, a lot has been said, but I actually want to take it from that perspective of it being an evidence rule. A lawyer is like we have said. Oh, my internet. Like we have said earlier, a lawyer is prohibited on all fronts to disclose whatever the client discloses with him or her. A lawyer is prevented, a lawyer is prevented from using it as a testimony. We can also see that from our evidence rule, section 192 or so of the evidence rule. It is prevented from testifying whatever the client has disclosed to him or her. So I want to look at it from that. But I don't know how to marry this because I have a lot of things on my table. But looking at it from the evidence side, if a lawyer is prohibited from testifying, from using it as an evidence, there are also some conditions that can be made. The condition of the confidentiality. You can't, for example, now a client be discussing with your attorney, generally in the public, where any other person can eavesdrop or any other person can hear, and you still want to hold your attorney onto it, like there's a strict confidentiality. It was discussed in the public, anybody could have picked it up. In that instance, it's foregone. Then also, like I said, if a client wants this to be private, I want it to be private. A lawyer is bound to keep it as private as private. No social media gist, because I read a lot on social media these days. My client says this, I went to court, my client did this, my client. These are wrong. And like Mr. Leo said earlier on, we gloss over these things a lot. I think the NBA needs a lot to do in, educating people, letting lawyers know that some of these things are so wrong. You don't come out and discuss what your partner has said to you in the public. A lot of things goes on the social media now. You read a lot of things from lawyers that you actually don't expect them to be there, but because they feel, I don't even think some of them know that these things are wrong in the first place. They just go out there, they say a lot of things, and they hide under the excuse of, okay, I didn't mention the person's name. That's what most of them says. But these things are wrong. Like he said earlier on, we need to do more on these things. The laws are there, but the implications, the applications are nowhere to be found. In fact, if you look at a lot of decided cases, the cases that have made it to court, when it comes to attorney-client privilege, they're so scanty, they are so low, because most of them don't make it to court. You see people having conflict of interest. Okay, I have a friend, let me give you an example. I have a friend that brings in someone, introduces a client to me, and at the end of the discussion between myself and the client, the friend comes in and wants to know, what did we discuss? What did he or she say? You see a lot of lawyers saying, okay, this is it, this is how it goes. It is wrong. These things are very wrong. Yeah, you are breaching confidentiality. Then I also want to point out that this thing even exceeds to after a client dies. When your client dies, it doesn't give the room for you to now start disclosing whatever you guys discussed, whatever confidentiality that was between you guys when the person was alive. It doesn't work that way. Even after death, you hold it. It's a street liability. You hold it even after death. Although there are exceptions to the rule. For example, okay, let me give an example. When a client is planning, when a client is planning, I'm trying to, a crime and confides in you. Like, okay, we are planning to rob Mr. Leo tomorrow. Are you, as my lawyer, I need to let you know so that you start preparing just in case I am caught. Okay, so that we start preparing how to come and bail me out. You as a lawyer, at that point, you have a duty to disclose, to call the police and let the police know that Mr. Leo's life is in danger. Some people are planning to rob Mr. Leo. Your street confidentiality does not cover that way. Then there's another case I want to bring to our attention. The judgment of the Federal High Court of the Registrar Trustees of the NBA versus Attorney General of the Federation and CBN. I don't know. I can provide the citations.
I think we lost her again.
Lawyers as non-financial organizations must also disclose under the Money Laundering Act that they must also disclose their financial. The NBA had to take CBN, EFCC, Attorney General of the Federation to court, and it was decided in court that no, if you are saying what you are saying lawyers should do contradicts their duty of confidentiality. They cannot disclose their financials. That's like disclosing the confidentiality between themselves and their clients. And that is why up to today, if under the slum, we lawyers are exempted. If you look at it, you see lawyers there, but you're not mandated. If you want to open bank account, if you want to do anything, to get a slum certificate. That's how severe, how entrenched this is. So let me stop there, then we'll probably pick it up from later.
Okay, thank you, Dolapo. Your passion actually made you jump the We're still trying to finalize discussions on the issue of conflicts of interest, but the points are well taken.
Sorry about that.
No, no worries, no worries. I think we'll make reference to that when we get to confidentiality. But just to tie up the issue of conflict of interest, just from what Mr. Okafor said, I completely agree with you, sir, that these things exist more in breaches than compliance. Of course, given all that will be involved in bringing an action to deal with conflict of interest issues, some people just decide to just take the L and move on. But you know, when we look at the law, when we look at law reports, we actually see that more and more clients are beginning to take steps to actually assert some form of claim against a lawyer who has engaged in not just a question of, you know, breach of conflict of interest, not just a question of an issue pertaining to conflict of interest, but breaches of, you know, general duties that are provided for under the rules of professional conduct. It's becoming more and more popular now for the disciplinary committee to step in to deal with some of these issues. And in fact, we've seen that, just speaking generally now as regards duties under the RPC, we've seen instances where even senior advocates of Nigeria have been stripped of their privileges due to, you know, certain breaches. So I believe that's a step in the right direction, showing that, you know, some of these issues which, you know, clients, you know, which clients view as being important as regards conflict of interest, as regards other duties provided for in the RPC, that there is some form of cause and effect scenario, such that where there's a breach, there's some penalty that would flow from that breach. That's definitely something that we're seeing in practice. However, we're definitely sure that it's occurring more in breaches than in compliance, as it were. If there are no more comments on conflicts, maybe we'll just dive straight into confidentiality. Dolapo has already led us down that path.
Wait, sorry, excuse me. I want to point something out. The breaches that we see a lot these days are more of professional misconduct between the client. I just want to differentiate that between the client and the lawyers. Not really because there's a distinction between the lawyer and attorney confidentiality. More of this that we are seeing that is becoming more rampant now is clients reporting their lawyers from generally professional misconduct. That's what we have most these days.
Yeah. Thanks for that point. And it further highlights the point I made, that because I mean, if you don't disclose conflict, that means you're in breach of actions against your lawyers, asserting that a lawyer has breached his duty under the RPC, either by failing to disclose conflict or by failing to disclose all aspects of conflict, or by engaging in some other acts under the RPC. So I completely agree with you that, you know, a lot of the cases relate to breach of, you know, professional what would be termed as professional conduct under the RPC. But one of those issues is as regards conflict of interest. I actually mentioned one of the cases that is reported in the Nigeria Weekly Law Report, where, you know, clients are actually taking a lawyer to task for failing to disclose his personal interest in a matter, despite the fact that he had been retained by the client to act for him. So that's something that we see. In the absence of any
I wanted to make one small comment.
Conflict. Okay.
I wanted to make one small comment in relation to this concept of Chinese walls that law firms hide under, you know. And I'll paint a scenario of when at some point, and I'll make it a company, someone drafted an agreement for us, and then we sent it out to another company, and then the firm that drafted the agreement for us came back with comments on the agreement they drafted for us. And when we brought it up, the concept of Chinese walls. And for me, I struggle to understand this concept, because how do you enforce it? Will you say that these employees are working on this contract will be barred off to another continent with no telecommunication, and they will not speak with the lawyers working on the opposite side? And I think this is something that should be seriously and highly discouraged
Yeah.
and discontinued, and people need to really take up law firms on this concept of Chinese walls that they keep on hiding under.
Yeah,
Hi,
that's
sorry.
okay.
Mrs. Adiola just joined us, so she is also one of the panelists.
Okay. Okay.
Yes, yes.
Welcome,
So she
Adiola.
raised her
Just
presentation in good time.
okay.
And
Thank
I'd
you.
like
Just
Ogona to respond to my comments.
I will. I was actually coming to that, and it's a valid concern, and I think it goes to what Mr. Okafor said earlier when he said that sometimes the size of the brief, gets into your head, and you just, throw all caution to the wind and run after it. I hear you completely on that, but the thing is that I suppose the reason why law firms, would say, okay, this is a situation where, despite the fact we can have that Chinese wall and we can adequately represent the interest of both parties, is that, the RPC suggests that you can do that. If you look at Rule 17.3, now, whether it can be properly enforced or carried out is a different issue. But if you look at 17.4 of the RPC, so it says that a lawyer should not accept an employment if the exercise of his professional judgment will be adversely affected by accepting that employment, or if it would involve him representing different interests, unless it is obvious that the lawyer can adequately represent the interest of each, and each consents to the representation. Where the challenge lies is that sometimes, some lawyers would not inform the person who has approached them to act for them that, oh, listen, I'm representing this other person, but I can still represent the two of you. I can have that Chinese wall and move on. Some people don't do that, right? Some people do that on the premise that I have a team that is large enough to deal with your respect. I mean, the transactions may be different, right? So the fact that I'm representing in transaction A does not mean that I can't represent the other party in transaction B, and then will approach you for consent. At least at that point, you have the opportunity to say yes or no. And that's the practice that should be encouraged. I don't believe that, and to be honest, that's the practice we have here at ALEX. We will definitely reach out to you to say, listen, we have this conflict. We don't think that it's significant conflict because it's a different transaction. There's a different team handling it and all of that. So we give you the opportunity to make that decision. Of course, if you're able to make that decision, then that's fine. The problem lies where, a lawyer decides that I can make this decision for you, right? This transaction will not affect my ability to represent somebody else. I think that's a practice that surely should be discouraged. In fact, it's a fireable offense. Eventually, if the client subsequently finds out, it's something that can lead to disengagement, and I don't think anybody would argue with that. Welcome, Adiola. We're discussing conflicts of interest. We've had interesting perspectives from in-house counsel and external counsel on the call. I don't know if you have something, if you have any points that you would want to make.
Thank you. And I'm not sure if Chidima explained what had happened to my system. Technology is definitely an amazing thing. So just to say, I mean, the point where Aramide made and what you responded, I think it's a very interesting thing that you said. However, I think the RPC actually makes it mandatory for you to disclose. So it's not a case of you have a choice. You actually don't have a choice as a lawyer. You must disclose. That responsibility to disclose is in the RPC. And also, it is, as you said, the client's final call and not the lawyer's call. So I'll just take questions because I had a slide prepared. I'm not sure how much of that has already been taken. So I'm not sure how you'd like us to proceed. If you just let me know what has been said so that I can look through my slides and decide what not to mention. I agreed with Chidima to focus on scenarios. I lost all of my slides this morning, unbelievably. It's still a shock for me. My IT team had been working for hours on it. We couldn't figure it out. So I tried to recreate it. I don't have all the scenarios, but I have a few scenarios also that we can all discuss also. I've made my own suggestions after each scenario, I made my suggestions, but of course, we can all come back to discuss the scenarios that I raised and what we think, and if we agree or disagree. So shall I do that?
Okay, let me ask, your slides, do you have anything pertaining to confidentiality?
So, yes, just one slide on confidentiality. That's what I have, so I can always skip that.
Okay, because I asked because I know the webinar is slated for an hour and a half. We've dwelt a bit on conflicts of interest, and we're almost running that conversation to move on to confidentiality.
Okay.
Before, Dolapo had already taken us into confidentiality, so it might help if you then help us move into the confidentiality part of it, so that we're able to manage time appropriately.
Okay, so what I've got really, from what Chidima asked me to do, I focused more on bringing up scenarios where conflict can arise. So I can move my slide to that part, and then we can discuss that. So I'll just share my screen. Okay, so all of this, I believe, has already been dealt with. I heard you talking about the obligation and the exception, so I'll just move on. So in my first scenario, so you're part of a team, a deal team that has been brought together by the client and has third parties because the client is interested in going into a business relationship. So as in-house counsel, you know that because you have external people also on that team working on the transaction, what kind of information should you give? Should you give information when they require it? And what should you do, really? That's what I had there. So it's just basically bringing up scenarios. For me, I had said, yes, you can provide information to the team, the deal team, provided that an NDA is signed with all the third parties and you don't disclose more than what is strictly required. And also check back to what Aramide had mentioned just when I joined, that you also have to check that all the third parties have confirmed in writing that they have no conflict of interest when they're representing your company. I also made a little note here that it doesn't apply to the other side of the table. So all of these suggestions doesn't mean that because you're working with company B to try and do a merger, you should give company B all of the information. No, this is for company A, you work with company A, and the team working with company A, the third parties working in company A. So should I go on, or do you want to make comments on each scenario?
Well, it might, I don't know if Aramide and Mr. Kafa want to, from the client side, could you go back to the scenario itself?
Sure.
I think Adela has answered it. Certainly, you should provide the relevant information. You need them to work on the deal. You need their advice and on strategy, how to execute or implement the deal under the law. And they need all the information from you to enable them advice from an informed position. And the best, like Adiola said, is to ensure that they execute the relevant confidentiality agreements. So I don't really see anything much to say on this point.
Okay. So scenario 2 is the issue of corporate fraud. The client is seeking advice from you. So initially I didn't go through the beginning of the slide. I had set the stage and mentioned that your client as in-house counsel, is important that you realize who your client is at every point in time. So as sometimes you are a client, your client should always be the company. You should always remember as in-house counsel that Your client is the company, not to individual directors, not to individual employees, even though the company works through all of these people. So in this scenario, I'm asking, just throwing this up again. So the client is asking you, because they want to commit fraud or regulatory non-compliance, as a lawyer, what should you do? This is your employer. Should you report to the regulator to say, look, I have a situation in my organization and I know that my organization does not intend to give you all of the information, or I've been asked to amend some things, I've been asked to do certain things. What should you do? I think I caught the tail end of Dolapo saying something about that when I joined. I'm not sure. So I'll see if Dolapo agrees with me on this. So my recommendation is to follow your whistleblower policy immediately, because it's a big issue. Keep track of your reports. Ideally, it's best to ensure that all of your reports and everything that you've done is in writing. Don't just mention to somebody by knocking on their door and saying, excuse me, have you got a moment? No, make sure that you document everything. And the reason why this is important is because in spite of sometimes you find that in spite of the whistleblower, in spite of the reporting to perhaps the CFO or the CEO, you just might find that they intend to proceed in spite of your recommendation. So that's why it's important that you keep track in writing, actually, of your reports. And where it is required, do not hesitate to escalate to either a trusted board member or a board audit committee. I suspect, a couple of people might feel, oh, then I might lose my job. But I think what's more important to you should be, and you can also lose your license. So do you want to keep your license as a lawyer and your reputation as a lawyer, or do you want to keep the job? Again, this must be done tactfully. It's not something that you're just going to say, oh, I have something to tell you. All of them are liars and they want to steal and rob the company blind. Have to find a tactful way of mentioning it. So I don't know if Dolapo has a comment. I see she smiled when I raised this on this also.
Okay, actually I do. Like you said, and also like I believe, you need to escalate, you need to do the whistleblowing, but you also need to understand the environment in which we are operating from. It's all enough to say, okay, I'm just going to lose my job, or I'm just going to lose my license. Well, in some instances, you may also lose your life. That's because there are some, as a lawyer working, there are some secrets that you are exposed to. Sometimes you can also just lose your life. So sometimes you need to also look around the temperament of the people you are working with and be a lot tactical. Like you said, I agree, you need to document, you need to do a whole lot of documentation. And if I actually do not agree with your part of confiding in, I wouldn't do that, because actually I don't, when it comes to, I'm sorry, but I need to say my mind, when it comes to corporates, board and all that, I believe it's a dog eat dog situation. So most times you might just feel this person has your back, but no, that person doesn't have your back. So you need to understand the environment in which you are. But that's my own perspective. Like, see, corporate board is dog for dog. So you need to hold your head first. So I agree with whistleblowing, and do a lot of documentation. Please do a lot of documentation to save your neck. And I actually want to go back to something Ugona said earlier on, consent. And you also, Adiola also mentioned it. I believe a lot of things are boiled down to consent. You get consent, and if you get consent, please document your consent. Have it with you, document it. Then I also believe that there are some situations that are just prohibited. Let me just put the prohibited representation. You cannot get consent on those ones. You just need to let go. Once you are on board, some situations arise when you're already on board, but immediately you're on board and you can see that these are not consentable situations, you need to withdraw. So I agree with the whistleblowing policy, but please be very sure of your environment. Your environment will guide you how to handle it. Thank you.
Thank you. I was hoping that Dr. Leo would also say something, because I know he's one of our guys in the ICSAN. So I know this is a big one for him. Can we drag you into the conversation?
Well, I will try to come into the conversation. Quite interesting anyway. And I agree with the suggestions you've mentioned here. A bit some on a lighter note, what if there's no one you can trust on the board? Just like Dolaboy and earlier insinuated or mentioned, because you never trust anyone. Love everybody, respect everybody, honor everybody, but they will say, look with your other eye behind too. But I agree with the very first two. Keep track of your reports. Speak the truth. If you are asked to do something, the very first response is, if you don't believe in that thing and you know it's not right, respond verbally, and then in writing. That is fine. But the idea of maybe rushing off to blow the whistle, what if the whistleblowing policy is not robust enough for the purpose of blowing? Assuming it is robust enough to blow. In some climes, you may blow the whistle. Unfortunately, nothing happens. You may also blow the whistle. While the whistle is still in your mouth, they may force it down your throat. And then I've seen situations in previous life where such things happened. But that is not to say that as an in-house counsel or as a company secretary, you must not stand by what is right. Documentation is key. So that when the chips are down, there'll be evidence that you not only spoke about the truth, but you also advised against it. So every situation must actually be treated diplomatically. Do not be in a hurry to respond to any situation. Think through it, and then ask your colleagues in the industry what they think. How will they respond to that situation if they are in your own shoe? Some may have gone through that situation in the past. I don't believe there's any situation a general counsel or a company secretary is going through that colleagues have not gone through and have some lessons to share with the person on how to manage it. So when I started on this, I had a number of people I ran to when the heat was high. And the advice helped me manage the situation. And today, when I look back, I just smile. And I share the same thing. And I have people to share the same situation time to address such situations. So it requires a lot of diplomacy. But your conscience must guide you at every point in time. Thank you.
Ajola, can I ask a question? Just flowing from what Mr. Kafo said. So he mentioned where the whistleblower policy is not robust enough. So what if the organization doesn't have a policy at all, right? So it's not clear to you, as some companies do anyway, it's not clear to you what exact steps you need to take, right? Would it in any instance be okay for, just speaking as an in-house person now, would it be in any instance be okay for that person to speak to legal counsel? When I mean legal counsel, external, before deciding on what to do, since there's a chance that your personal, your head, as the LACPO referred to, would also be at stake. Is there a chance that could be, particularly if there's nobody you trust? I'm just wondering, let's put it out there.
So the way I would handle this, I'm not likely to speak to my external counsel. Okay. I most likely will toe the line that Dr. Kafo has said and speak to somebody else in the industry that is trusted. The reason why I would not be quick to talk to my external counsel is because, sometimes if they've worked with you for so long, and what you typically find has happened is that they also have people that they relate well with within the organization. If it's something as sensitive as that, it's not something I'll be quick to talk to an external counsel on, I'll probably call a Dr. Leo, and or call somebody that I feel I'm comfortable with, that is a senior in the industry, and say, this is what I'm going through, this is what's going on. I mean, not that I would give all of the details, just enough information for the person to understand the dilemma and then to advise on the best strategy on how to deal with that if there's no whistleblower strategy. But yes, I definitely will not keep quiet or decide that I would roll with the punches, so to speak, you know, and say, because I have a job to do, I don't want to lose my job, then I'll just let them go on with fraud. No, it's definitely not something I'll do. So I will speak to somebody else, but not external counsel.
Would that then lead to fears of confidentiality, breach of confidentiality, speaking to somebody outside the organization, as opposed to your external counsel who owes you that duty to keep whatever you say confidential?
So, you know, when Dolapo was speaking so passionately, you can understand why she would speak so passionately. At that moment, what you're looking for is not immediately legal advice. What you're looking for is professional advice. So to speak to my external counsel, I'm expecting them to give me what they owe me is legal advice. And you must always separate that. I have that in the slide, but we didn't go through it. The difference between professional advice and legal advice. And you must always differentiate between that. So what my external counsel owes me is not professional advice, you know. So that's why I will be speaking to, if you have a mentor, I have a mentor, I will be speaking to my mentor concerning this and say, this is this. And again, I mentioned earlier that you have to be careful. And when you're speaking to someone senior, they won't require to know, for example, if it has to do with numbers, to know the numbers, to know which director did what. You know, you can tell them enough for them to understand the scenario. Dr. Leo had mentioned earlier that, you know, in his, when he was a much younger lawyer, he's had situations where he had to run to someone. You know, it's not that afterwards, we've all seen in the newspapers that Dr. Leo came to me and I said, you know, it's not likely to happen if you're speaking confidentially to someone who is more senior in the organization. So that's the way I would approach it.
I'm sorry, I think I hold a different view. And if we can go back to the previous slide, I think the issue is one of confidentiality. Maybe we should take it back there. And I think the first question to ask ourselves, when someone comes to you, and let me just look at the question.
Do you mean this slide or
yes,
the deal team
yes,
slide?
The corporate fraud, yes.
Right, okay.
Now, from an in-house perspective, your client is your organization, right? Now, your MD comes to you and talks that says he wants to do X, Y, Z, and that's against the law. The first question is, does this form part of attorney-client privilege? Is this something I need to, I'm required under law not to disclose? I think we should sort of focus on that and also discuss that as well. What are the exceptions? Because the Evidence Act says that no legal practitioner shall disclose any communication made to him in the course of employment as a legal practitioner. Now, your MD comes to meet you. You said, Adiola, that your client as an in-house counsel is the organization and not the agents. Now, in some cases, and even though, yes, there are no Nigerian law cases that talk about this, so a lot of reference will be made on foreign cases. Some cases, they've regarded even officers in the company as agents of the company, such that when they're coming to you for legal advice, it's caught under the attorney-client privilege, and then seeking advice from someone else on that particular matter, even though you may not refer, or you may not call the name of the client, but at times, even talking about certain situations, the other person will know, and you'll be in breach. So saying that we're seeking advice from other seniors in the field, that may also be deemed to be a breach of client attorney privilege. One thing I wanted to mention is when someone is seeking to, for the benefit of others that are watching, when fraud, there are exceptions to the attorney-client privilege. And when someone is seeking to perpetrate a fraud or commit something that is illegal, then you are not caught within that obligation, and you're well within your rights to actually even take it up with the police or report to whoever or discuss it out. But when someone else comes to meet you, we need to draw that fine line so that it's clear when you're seeking advice from someone else, that may be a breach of your attorney-client privilege. Now, when someone else comes to meet you and one thing I'd mentioned at the beginning is that as an in-house counsel, you wear many hats. When you wear, I'm the legal advisor, I'm advising on this issue, I'm the business partner. So what matters are caught under the attorney-client privilege. When you're issuing an opinion on something, is that caught under attorney-client privilege? When they call me to a meeting to discuss business matters and they're giving me information, is that too caught under attorney-client privilege? I would like us to address these kind of issues. These are yes, your question, but also in view of the fact that we don't have a lot of time, I would also like us to address all these different type of scenarios.
So Aramide, I honestly don't think that at any, and again, that's me, I don't think that because it's a fraud that we're talking about, I should go to the police to inform them that my organization is about to commit fraud or somebody in my organization.
No, sorry
is
to
about
cut you off. No,
Okay.
sorry. I didn't say that the way is to go to the police. What I said is that you're well within your rights. So I'm not talking about best steps now. I'm talking about what is deemed confidential and what is not deemed confidential. That's what I'm saying. So I'm not saying that the next thing to do is run to the police, no.
Okay.
I'm talking about in terms of what is confidential and exceptions to the rule of confidentiality. I thought to make that clear.
Thank you. Thank you for clarifying that, because I thought to myself, I'm not sure you actually, I mean, it's back to what you were saying, and I'm not sure you actually are let off the hook and say, oh, because it's fraud, I'm just going to go straight to the
No, but my point actually is that seeking opinion can be deemed to be a breach of the client attorney privilege. And that's something we need to be careful about.
I agree.
Opinions.
I agree with you. For me, because this is a delicate matter, and because it's not something that you like, I think it was Dr. Leo Delapo that mentioned, it's something you want to think through carefully. The scenario we're discussing right now is when there is no whistleblower policy. So you don't know how best to go about this issue. Who do I go to? I'm not sure I should go to Mr. X or Mr. Y, which is why there's the problem. So in that situation, for me, my first reaction would be to be guided. How best should I be reacting to this? And again, I think it just all depends on how much information you give and what you give. Boils down again to common sense, as Ogona started us off with. It boils down to common sense, use your head. But that's the way I would approach it. I guess we all have different ways of looking at it, but that's how I'd approach it.
Okay. Let me make this point. Sorry, let me make this point in relation to what Aramide mentioned as to what would constitute confidential information. Now, if you look at Rule 19 of the RPC, that rule says that all written or all oral or written made by a client to his lawyer in the normal course of professional employment are privileged, right? Yes. Meaning that you can't disclose. Now, if you go to the Evidence Act then says that you cannot, as a lawyer, you cannot disclose any communication made to you in the course for the purpose of his employment as such legal practitioner by or on behalf of his client. Now, an argument can be made. I'm not saying that it's the fact, but an argument can be made that as a lawyer, you're engaged or retained to provide legal services to your client. Those legal services, of course, cannot be for the purpose of carrying out an illegal activity, right? So it's required to keep confidential the information or communication that you have received for the purpose of providing legal services to your clients as contemplated under Nigeria's laws. So if your client is now pushing you to facilitate or to commit an illegal activity, at that point, it's fallen outside the scope of your duty as provided for under the RPC or the Evidence Act, which I suppose is why in the Evidence Act in section 192A, there's now an exception which says that nothing shall protect from disclosure any communication made in furtherance of any illegal purpose. I suppose that's why that has been carved out from that general duty not to disclose. So tying that into what we're discussing now, you know, my initial disposition was that, you know, first the scenario says your client, so the company has approached you, an officer in the company or any agent has approached you for advice in order to commit fraud or regulatory non-compliance. I suppose we're looking at this not from a strictly legal standpoint, which is why Adiola and Leo spoke of, you know, speaking to somebody to get advice and all of that. I suppose we're trying to see how to manage the situation so as not to expose yourself to legal penalties that would arise from engaging in illegal activity, which is why you may want to reach out to somebody to talk to. But I also had that problem with going outside to speak to somebody. I understand you redact, you provide, you know, limited information so as not to reveal everything, right, to the other party that you're speaking to. But what if the party you're speaking to works with a competitor, such that the mere notion that that kind of activity is being contemplated can actually expose you to potential action from a company, such as reporting you, filing at least now under the Whistleblower Act, you're able to file an anonymous petition, right, with the police or with EFCC or any other graft agency. So I'm wondering whether even if you as much as possible try to withhold specific information, you go down that path of speaking to somebody you feel you trust, and it then turns out that you're actually exposing stuff that could potentially prejudice your company's operations, whether that in itself won't present a problem. That's the reason why I raised.
Let me take a first shot at your question, Ogona. So I think one of my favorite sentences that I've heard today is use your head. I'm still not sure if it was Dolapo or Dr. Leo that said that. So I mean, you are in that position because you are trusted. You're in that position because, you know, you understand the obligations, or at least it's expected that you understand your obligations. I don't expect that you would actually go and talk to a competitor and say, oh, because the person is my mentor, or the person is someone I speak to, then that's what I'll do. And don't forget that the scenario we're contemplating now is a scenario where you don't have a whistleblowing policy. You don't know exactly how to proceed. Yeah. Yes. So that's why the suggestion of, you might want to speak to somebody who's gone through this before to say, okay, in the event that something makes me uncomfortable and I don't have a whistleblowing policy, what's the best way to proceed? When you ask somebody that question, you haven't told him it's fraud, you haven't told him it's not fraud, you haven't told him it's this, you haven't told him it's that. All you've said is, look, I'm very uncomfortable with a particular thing. I'm not sure how I should be proceeding in this instance. Again, it's a case of use your head. And oftentimes what I find with seniors that I relate with is they usually will not probe you to ask you too many questions, because they also understand that you have a duty to protect. So they would give you wide scenarios so that you can help you. Nobody is going to hold your hand through the entire process. They are going to give you guidelines on this is what you can do. Have you tried speaking to this? Is this available to you? Can you do this? What if this? You know, they would usually talk you through asking you probing questions that will help you figure it out together. That's what I've found. And when you're asking a question like that, you will find the guidance you need without actually having to say, so in my office today, we had a situation where they brought me some files. They said I should sign off, and I know that it's supposed to be 10 million, but they said it's 5 billion. I mean, come on. I'm not sure even a lawyer who was called to buy a new wig would do that. And if there's someone here who would have done that in the past, please don't do that. And that's not what we're advising. And I'm interested to hear what other people think.
Okay, let me quickly add to what you have just said. I think this whole thing, because I don't see, we need to differentiate between asking for, like you said earlier, professional advice and the attorney-client relationship. It's all about information management. You need to use your head to save yourself. You manage information.
Oh, you're the one I'm looking for. Use your head.
The thing is, you need to, I'm going to go and meet Mr. Leo, for example. Somebody has asked me in my work to inflate equity shares, for example. I'm not going to go and meet Mr. Leo and start telling Mr. Leo, we are going to the market, or they said we should inflate equity market shares. No, I'm just going to ask Mr. Leo blanket questions. Mr. Leo himself is old enough to know that I am prohibited divulging such information. So Mr. Leo is just going to guide me along the general line. In that instance, I don't think I have breached any attorney-client relationship. It's just for me asking professional advice. And it also means that we also need to also be discreet. Know people who are matured enough for you to confide in. Because even at that, you see a lot of seniors, well, talk too much. We need to be practical in these things. We all are in these things. Talk too much most times. So you need to really also be discerning who you go and meet. And when you go, manage your information and do a lot of documentation. Thank you.
I'm thinking whether it's not,
sorry.
I hear you, and I think it's a thin line. I'm thinking whether it's not simpler and probably more cautious a strategy to so if you're approached by somebody in the company, you have a conversation with the person. Okay, so is this what you want to do? Okay, fine. Can we find out what impact this course of action could potentially have on officers of the company and the business? And then you get, I don't know, external counsel to do a legal opinion for you as to the potential impact in terms of, no, I'm not chasing business here. I'm just thinking.
Are you sure?
Yes, I'm very sure. I'm not chasing business here. I'm just thinking that it might be, because for me, I feel like there are lots of things that, once you start speaking to people outside the organization, there are people you think you might. Yes. Yes. So just
Ugonna, can I ask?
Sorry, I need to make a small
point.
Sorry, sorry, Gona, I need to make a small point.
Okay, cool.
I think we need to be clear as lawyers, right?
Yeah.
And there's one thing to, okay, what's the best way out of your problem?
Yeah.
Right. There's another thing that the best way out of your problem, what's the risk? Can it result in a breach of the attorney-client privilege? Now, whilst, yes, people that are 10 years or 15 years, they know how to go about seeking advice. Not everyone knows how to do so, and we need to be mindful of the advice we put out there, or because there are a lot of people listening to us. Even within firms working on transactions, there are times that even within a large firm, and Gona, you'll be used to this, that certain people in certain teams don't talk to anybody about certain transactions going on at all, notwithstanding they're in the same firm. So in this, yes, you're seeking advice, and yes, you'll be discreet, but there's even a way that I'm talking to somebody, and it's not necessarily a competitor. You'll never know what the person can use that information for, and it doesn't even have to be a competitor. In that, in seeking advice, do you run the risk of running foul of attorney-client privilege, notwithstanding the fact that, yes, you're seeking advice on one? I think it's important, using this your example, and that's why I made it clear that when it comes to illegal matters, those are not covered. But now let's talk about when something is like a normal, we are seeking advice from a third party. We need to be very careful. Yes, you may go about it discreetly, but even in being discreet, the real question is, can you run foul? What's the risk? Do you run foul of attorney-client privilege? And it's really not about how discreet you are.
Yeah. In fact, just to mention that for our experience usually is that in situations like this, we usually are prompted by the client to provide a legal opinion on the pros and cons of a particular, strategy or course of action. Now, you don't have to worry about the confidentiality issue because, of course, as your lawyers, whatever you say to us is confidential. Now, if as the in-house counsel or the company secretary, you then take the legal opinion that has been provided by your trusted counsel, and then you go to the board or you go to a few select members of the board and say to this is what our lawyers think. If having put forward the pros and cons of that particular course of action, I suppose it could in itself prompt a turnaround if the officers of the company were looking to go down an unlawful or illegal path, or at least serve as some form of protection for you in your position as in-house counsel. For me, we've been in that position a few times where we've had to say to the client, you can't do this because of ABC provisions of the law and the penalties that are provided for under the law. And
just before Aramide spoke, I was going to ask you a question, and so I'd like to hear Aramide's thoughts also.
Okay.
So usually, typically, what you find is before you write to your external counsel, you would need the approval of your CEO, because somebody has to approve it. When the right, you have to pay them, right?
Yeah.
So I'm wondering how best you would go to your CEO, assume your CEO is aware of this fraud, and say, sir, in this matter, I'm quite uncomfortable. I want to go to external counsel to get their advice. And then he says, no, this is not something that, you're supposed to disclose to anybody. You have to keep this one, within us, because oftentimes when somebody wants to do something like this, it's not because they don't know.
Yeah.
It's not because they are totally ignorant. It's a different case if they've come to you because they are ignorant. It's not that they don't know. They know what they want to do, and they're asking you how best to go about it and to achieve this. So you've proposed that you want to talk to in-house counsel, and they've said, no, this is something we want you to handle internally. How would you then proceed?
In situations like that, I'm usually very clear, and while respecting the work that in-house counsel do, I'm also able to do that work myself. It's a starting position. I'll write an opinion and I'll put my thoughts in writing. And I've done that from time to time, and I say, this is the position of the law. This is so that if push comes down to shove and then regulatory authorities come and all, it's a crime. That I think the starting point is that it's a crime.
Sorry, Aramide, remember we had dealt with that already. If you go back to this slide, we had said that, you are going to do your report, you're going to keep track. You're going to...
No, I'm not talking about keeping track now. I'm saying rather than ask an external advisor, in my case, I'm free to contract out and I don't need the permission of my MD or financial director to contract out to external advisors. But if I was under that restriction, I would put my thoughts in writing and I would say, this is this thing this is what the law says. This is what your action or your suggestion is against the law for XYZ reasons. I'll put that in writing and I'll take a stand.
And they refuse. The scenario here is that, you know, they refuse. So what do you do next? This is the course they want to go. This is how they want to go. So that's why we're saying, so what do you do? This is what they want to do. You've said, you know, I don't agree. I don't think this is advisable. You know, so what else do you do?
Then you escalate my suggestion is you escalate to your chairman, but just be prepared that obviously you may be prepared to lose your job if it comes to that. And I think that's a stand that every legal practitioner at some point needs to take, because when the regulatory authorities come, they won't say, oh, I disagreed. No, you're part and parcel of that decision. And that's, in my own situation, that is what I will do. I would escalate, I would put my thoughts in writing, I'll put my objections, I'll say my position in writing, I'll try and engage the chairman. And when it comes to that point, then you'll take a decision. But because we're talking about confidentiality here and just bringing us back, so it's not the issue is what conversations will run foul of attorney-client privilege and what conversations will not. It's not really about managing, at least to my mind, it's not really about managing situations. And Ogona, you can correct me if I'm wrong. And in that case, because it's outside the law, you are well within your rights to disclose, and it doesn't come under attorney-client privilege.
Okay, I'm so glad this generated a lot of discussion. I'm not sure where, if we found one way or the other to birth this ship.
I was hoping to get a final word from Dr. Kafo before we leave.
That's a good idea. And listening to us, yes.
Quite an interesting discussion so far. And like I would say in 2 words, it requires caution. You cannot say because of confidentiality, you allow the problem to overwhelm you. And then becomes an issue of health you can struggle with all through your life. But caution in the sense, you look at the pros and cons regarding what the law says and the regulations say, and the need to seek advice. You cannot know it all. And when you, first of all, like Andramide had mentioned, of course, before you seek if assuming they will approve, you seek an external opinion, you will have to state what your own opinion is in the first place, because they want to know what you think about it. Even if they don't ask you, you tell them what you think. And if they're in doubt, you can then say, okay, let's get another opinion externally to compare with what I have said. If that's rejected, fine. Important thing is you've made your position clear. Where is something that's totally illegal, fraudulent, or criminal, let me use that word in that sense, don't be a party to it. If it requires a signature, say no. Simple as that. If it costs you your job, fine. But I know clearly when the chips are down, depending on the industry and your regulator, they will restate you clearly. And of course, as Company Secretary, the law is there as procedures as to how you can be removed, both under the old command and the current command. There are steps. So nobody can say the fact that you express a proper and legal opinion, you had committed an infringement or an infraction that require your removal. Processes have to be followed. So I'm just trying to use this to maybe cement this discussion regarding this particular discussion we're having now. Otherwise, we can go on and on endlessly with
definitely. Definitely. In fact, we've been prompted the webinar is supposed to end at 2:30 p.m. So we have 5 minutes to just quickly look at. I think there's just one question in the chat. I'll just read that out.
Yes.
I think it's been dealt with somehow, but yeah, let me just read that. It's from Blessing Nwankwo. The question is, what if you're in a very tense atmosphere that could actually take your life? What would you do? you know you should not, and you're not even ready to do anything fraudulent? Secondly, what if all board members are in support of the fraud? I think the first part of I think actually the question has been addressed by some of the things we've already discussed, particularly Dr. Kafo's closing remark. I don't know if any person wants to use a minute or a minute 30 to add anything else, but I think this has been addressed in all that has been said. I don't know whether we have a final landing point, but at least we understand, everyone's views on this.
Okay. All right, since it has been addressed, then I think we can end the webinar. Okay. So thank you to our speakers for joining us today. Thank you to our attendees for being part of this webinar. A very big thank you to our sponsors, Alex, GLIS, Bloomfield Law Practice, and Advocate Law Practice for making this webinar possible today. Our next webinar series will be on Friday by 11 a.m. and the topic will be on funding innovation in Nigeria. Lastly, please subscribe to our YouTube channel at My ESQ Legal. Thank you again, our panelists, for joining us today. Have a lovely day.
Thank you. Thank you all. Nice to meet you.
Thank you all.
Thank you.
Yeah.
Thank you, Chidinma. Thank you,
Thank you.
Thank you, everyone. Thank you for the lively discussions.
Yes, nice to meet you all. Hopefully, we'll continue this on other forums.
Absolutely. I have other scenarios for you, Ogona.
I'm happy
And
to receive.
Aramide.
I'm happy to receive that.
Thank you.
I suppose I'll get the contact details for everyone.
Yes,
Maybe if you're able to share the slides, I'm sure we'll all benefit from it.
Yes, we all benefit from
Yes,
it.
I have quite a number of other scenarios. I
Yeah.
wish we could have more, but okay.
Just get
All
our
right then.
contact. We'll be
Bye.
happy to have them.
Okay,
Bye.
thank you. Bye.
Thank you. All right, bye.